All right, court still in the sidebar, so give us a chance to bring in our criminal defense attorney, Keith Murray. Keith, we continue to listen to the testimony. Dr. Barry Logan, lay it out for our viewers. This is not easy stuff to really digest. And what is the importance here? The defense is trying to get him to say protocols at the Oak Ridge National Lab where Dr. Vass works aren't protocols, right? It's the whole junk science thing, right?
It's not necessarily junk science, because I got a master's in forensic science. I'm a total science geek, and I really believe that Dr. Vass is onto something. I just don't think it's ready for court yet. They're talking about sampling 4 byproducts of human decomposition, and the state's putting out there that that's the end of it. But the fact is that these 4 byproducts, these 4 fatty acids, can also be found in some common household dairy products. And the thing about the gas chromatography mass spectometry is it only tells you what it is that you put into it to sample. So if it can't discern between human decompositional fatty acid and dairy product fatty acid, all it's going to do is tell you it found fatty acid. And it's up to the examiner, the lab tester, to determine through the circumstances what that is. So it's subjective to the point where it's only going to tell you what you put into it. The machine doesn't know what you put into it.
First off, kudos to you. You do know your stuff. So, and that's great for us as we lay this out here. So with that said, is the defense winning? And by the way, they do want it to appear as junk science, don't they? To the jury?
Yeah. And again, I don't think it's junk science.
No,
I think it's not ready for court. And I think the state really should have just put on, let's say we got 5 or 6 cops here. They've done murder investigations. They know the smell of death. I've been around it. It's very distinct. It stays with you for weeks. Get 3 cops up there to say, I know what the smell of death is. The trunk of that car smelled like death, and leave it at that. I think they have ridiculously overcompensated trying to put this air sample forensic testing on when it's not ready. And you see how much back and forth is going on here between the defense and the state and all these competing witnesses about whether or not it's valid science. I think the state would have done much better to streamline their case and just leave it out and leave it to cops to say, I've smelled death, you know, here it is.
And when you're talking about the air samples, you're talking about Dr. Arpad Vass. So you're saying at this point, the state should have just kept him out and go with the smell of death between humans and even the dogs that smell as well.
Yep. Police officers could very easily have gotten up there and said, I'm experienced in it, I know the smell, that was the smell. And that would have been the end of it.
So what happens then when you get too much of something like this? Does confusion then equal reasonable doubt when a jury is left grappling with things they really don't understand?
It can, or, I mean, it can backfire on the state because the jurors might get confused. But one of the kind of disturbing things to me as a defense attorney that I'm seeing in the tweets that are coming out on your Facebook pages from the courtroom is that the jurors aren't taking notes when the defense is putting on its case. As a defense attorney, that would be a huge red flag for me, that, you know, maybe they've already made up their minds, which would be a breach of their duty as jurors to keep their minds open until the end of the case, and it might be able to be manufactured into an appealable issue.
Gotcha.
But I think this is all this stuff about the smell of death in that trunk is dragging out way too long. I mean, we've been on trial for, what, 3 weeks now? And we've spent an inordinate amount of time on this one subject.
And with that said, when you talk about simplifying, that's where Jeff Ashton comes in, when he follows up here and tries to simplify as he tries to tear down some of these defense experts, right? To leave the jury with
he's getting a little snarky and impatient. Yeah, he's getting a little snarky and impatient up there. You know, you just saw him go to the evidence table, grab a couple of the paint cans and a couple of those little air sample kits, and not necessarily slam them down on the bench in front of this witness, but he's making a show out of where you sent this stuff to sample yourself, and he wasn't. And I think that's because he feels like he may be getting a little knocked around by this testimony.
Gotcha.
He's getting a little short with the witness.
And he's trying to say that, Dr. Logan, you wouldn't know what to do or how to test this stuff.
Yeah, I mean, Dr. Logan's lab is apparently a toxicology lab, and it's a forensics lab, so they would not necessarily do that kind of testing in his lab. But if he's got a gas chromatographer mass spectrometer there, he certainly would be capable of doing that test if it was something his lab engaged in.
Okay. Well, the jury, just to keep everybody updated, the jury has been dismissed. They're going to take up some matters outside of the jury's presence. So let's take this last 40 seconds or so, listen in to see what, are they hitting anything, guys? As of yet, I don't see. I see Dorothy Clay Sims, Jose Baez. Okay, let's stay with Keith then. So, all right, Keith, as far as a juror today, is anything sticking with this jury as they go back and forth, or is the jury like what you're hinting at, all right, I got it, enough?
Yeah, I think the single biggest thing that's probably sticking with the jury are Casey Anthony's lies, and of course they and we are all waiting to see if she goes on and what she says. I think the forensic science stuff is just getting overdone and confusing.
Okay. Keith, good stuff again. You're watching HLN News Now and our continuing coverage of the Casey Anthony murder trial. All right, we've been watching as there's been a legal battle over a line of questioning. Prosecutor Jeff Ashton wanted to go after Dr. Barry Logan. Again, he's a forensic toxicologist. Dr. Logan has been looking at what was done at the Oak Ridge National Laboratory by Dr. Arpad Vass. And then Jeff Ashton wanted to go on a line of questioning about, okay, can you reproduce? He was asked by the defense, can you reproduce these results? He said no, so Ashton wanted to ask him why not. And that's where things stopped. Jury out of the courtroom. Now they're in a 10-minute recess as they review another case to get this finally settled. Let's bring in our criminal defense attorney, Keith Murray. Okay, a lot of legal wrangling going on here, Keith. What do you make of it as we watch this unfold?
I'm taking a lot of notes here. I've been writing furiously the last 10 or 15 minutes, and you teed it up exactly right. On redirect, Dr. Logan was asked if he could reproduce Vass's experiment. Now, the problem is that this is slightly outside, it's not slightly, it's outside of his area of expertise. The judge didn't put a stop to it at that point, and the defense is kind of crossing a line asking him about forensic testimony in an area he doesn't practice. So the defense came up and started on recross to say, well, why can't you? Which I think is a valid question because it goes to the lab protocols and Dr. Vass's publication of the lab protocols that he used to do this. But the thing that stepped over the line is, did you try? And they can't ask that because the state has the burden of proof, and that shifts the burden of proof to the defense, which is impermissible. It violates due process. But what's happened is the judge appears to be kind of backtracking a little bit. He sustained the defense's objection as to that line of questioning, but he's already kind of opened up a little morass here because the defense expert is already testifying in an area that he really shouldn't have been testifying in the first place. And I think right now we're kind of at a point where both sides have stepped over the line. The state's running the risk of shifting the burden of proof. The defense is questioning an area you shouldn't have been questioned. He's impermissibly impeaching Dr. Vass because he didn't run his own competing experiment. The defense already put a witness on yesterday that did that exact thing and testified, if I remember correctly. So there's a whole procedural area here that just got really confusing to everybody.
You sure did.
And this is,
you're giving us a good legal 101 lesson here. So what does Judge Perry do now to undo what's been done over the last half hour?
That's the big question. I mean, that's why, he's sitting there from the bench, and it's impressive. I got to say, I've had my issues with this judge and some of his rulings, but he's very good on the fly. He's very good at doing research on the bench and kind of educating both sides of attorneys as to what the permissible precedents are. So I think he's taking a few minutes now to do a little bit more research without the distraction of the arguments. To see if he can come up with a better solution to this. The defense is saying we want a curative instruction. Basically, saying that you can't shift the burden of proof to the defense. The state kind of stepped over it by saying, oh, Your Honor, we don't need a curative instruction. That's not the state's job. The judge determines that.
Right.
So I think Judge Perry is, this is another one of those situations where everybody's kind of getting at everybody else, and the judge needs to
Jeff
take a step
Ashton,
back,
he's not the take charge type, is he? Yeah.
No, not at all.
Okay. Good stuff, though, Keith.
A little impatient.
Yeah, we're watching this one unfold. Court in recess, by the way, as Judge said, for about 10 minutes. That gets us back in about 2:35, so we'll have a chance ourselves to highlight some of the day's testimony and also talk about whether or not Cindy Anthony will take the stand, and if so, how will she be handled by the defense and the prosecution this time around? More coming up. Stay with us.